All right, good afternoon, everyone. We're going to go ahead and get started because we've got lots to chat about today. So before we jump into the content, just some housekeeping. Just please keep in mind that these webinars are intended for educational purposes only. Now, while we hope that you do learn new information, the trainers presenting these webinars are not attorneys. Therefore, all information provided during the presentation and the Q&A session should not be construed as legal advice. All right, so now that we got that out of the way, good afternoon. My name is Brianna Grimes, and I would like to welcome you to our second installment of our December mini-series on 2021 state law updates. Today, we're going to be talking about Arizona, Colorado, New Mexico, and Washington. And I'm sure you will all have a lot of questions, so please feel free to type those questions into the question box as we are going through the presentation. Kathy is here on the webinar with me to be facilitating those questions and possibly answering some of them as we go along. If there's any information that you missed or if you had a technical glitch and you couldn't hear something, she can definitely clarify anything on there if you have questions. Also, please keep in mind at the very end, we are going to do a Q&A session, and some of your questions may not have immediate answers. These are new or expanded laws, and they are subject to legal interpretation, and some of them have not even been clarified from a legislature standpoint. So we will do our absolute best to answer the questions as best we can, but where they are ambiguous, we may need to do a little bit more research and get back to you guys after the end of the presentation. So just keep that in mind. All right, well, with that being said, let's go ahead and jump into our content today. All right, so today we're going to be talking about in Arizona, we'll talk about the minimum wage increase as well as Prop 207 that recently passed, which legalized recreational marijuana. In Colorado, we have lots to talk about. We're going to talk about the minimum wage increase in Denver and the possibility of a minimum wage increase across the state, the minimum salary threshold increase, the Equal Pay for Equal Work Act, the Ban the Box Act that was passed, and Healthy Families and Workplaces Act. And then in New Mexico, not a lot going on there. We'll go ahead and talk about their minimum wage increase. And then in Washington, we've got a little bit there. We will cover the minimum wage increase, the minimum salary requirements that are changing, and then their update to their sexual harassment training requirements for 2021. All right, so let's start off with Arizona. The first major change for Arizona is their annual minimum wage increase is beginning. So beginning on January 1st of 2021, the minimum wage in Arizona will increase to $12.15 per hour. Now, remember that minimum wage increases will be occurring annually going forward, and they will be based on the percentage increase in cost of living for Arizona based on an August to August of the preceding year. So that increase is going to be based on August of 2019 into August of 2020, August 2020 into 2021 is how they're going to be doing that period of time. The state is going to use the Consumer Price Index during that period of time to determine the increase amount. So what are the action items you need to take as employers? Well, be sure to conduct a wage audit to identify any employees that will not meet the minimum wage in 2021 and prepare to adjust their wages so their new pay will go into effect January 1st of 2021. All right, next we're going to talk about the big one. So the legalization of marijuana in Arizona, also known as Prop 207. So that is correct. You heard it right. Arizona passed Prop 207 during the most recent election this year, and they have joined the 14 other states that have legalized recreational or also known as non-medicinal marijuana use. This act is called the Smart and Safe Arizona Act, which makes recreational marijuana use legal for anyone over the age of 21. The deadline for state officials to implement regulations on the usage is April 5th of 2021. So essentially, that's around the time that the official laws surrounding this proposition will go into effect. However, based on experience, we know that that is subject to change. They may really wow us and make decisions on regulations early, but sometimes these types of deadlines do get pushed back, so we may not know anything until the summer. Now, I know many business owners hear legalize marijuana and they may panic a little bit because there are so many implications to your businesses. Luckily, with Prop 207, there were many critical restrictions put into place that protect businesses and eliminates marijuana usage from kind of being like a free-for-all type arrangement, which some people may see it as. So the first restriction is that the law actually does not restrict the rights of employers to maintain a drug and alcohol-free workplace or affect your ability as employers to have workplace policies that restrict the use of marijuana by employees or prospective employees. The second restriction is that the employer is not required to allow or accommodate the use of consumption, possession, transfer, display, transportation, sales, or cultivation of marijuana in a place of employment. Now remember that this is specifically referring to non-medicinal use of marijuana, so you are still required by the ADA to make a reasonable accommodation where you're able to accommodate medicinal use of marijuana with proper medical documentation. Now, this restriction goes on further to say that it also does not restrict employers' rights to prohibit or regulate conduct otherwise allowed by Arizona law when such conduct occurs on or in their property. So you still have that ability to regulate conduct on your premises and within your job sites. And finally, the third restriction that was put into place is that the initiative also specifies that it does not allow driving while impaired to even the slightest degree by marijuana. So any employees who drive for your company will not be permitted to be impaired by recreational marijuana usage, and you are still allowed to regulate that within your business. In addition, like other types of usage, such as smoking, smoking marijuana will remain illegal in public places as restricted by the Smoke-Free Arizona Act. So it's not something that they can do on their breaks or anything like that either. Now, as far as action items go here, there are a few things that you can do right now to prepare yourself for questions from your employees. Most employees, as we know, don't really read the laws. They read the headlines in the newspaper that says, recreational marijuana legalized, and they don't necessarily always read the fine print. So it is best practice to be preemptive and communicate with them possibly what this new law means for the company rather than have them think that it's a free-for-all on marijuana, and then you find out the hard way that they're impaired at work. So remember that from a federal standpoint, use and possession of marijuana and their products is still illegal. Therefore, any federal employees or employees in a federally regulated job or federal contracted employees can still be prohibited from using marijuana regardless of the state law. So keep that in mind if you have any federal employees or contracts that you work with. So as far as action items go, definitely start by looking at your current drug and alcohol policies, including those related to drug testing, and see if you want to make any changes or updates with regards to this policy. Some organizations decide once it becomes legal in the state, they just decide that they don't want to deal with it and they don't test for marijuana in the pre-employment drug testing. Again, with this proposition, you are not restricted to do so, but definitely now is a great time to revisit your drug and alcohol testing policies just to see if you or your leadership team want to make any changes. Then definitely clearly communicate with your employees what the company expects in light of this new law. So if you're still going to require employment drug testing or drug testing immediately following a vehicle accident and you're still restricting the use of recreational marijuana, and they do need a doctor's note or some type of medical documentation in order to use marijuana as an accommodation, then definitely let them know that that is still the case. But remember that it is still illegal to discriminate against the medicinal marijuana usage. So make sure that in any language that you're communicating with your employees regarding this new law, that you make it very, very clear that the accommodation for medicinal marijuana is not included. This is strictly your guys' policy on the changes to recreational marijuana. And then while you are editing your policies, you can always check out the Arizona opt-in statute for drug testing. Now, essentially, if an employer follows its mandates, generally they are protected from liability associated with acting on test results. However, to meet these requirements, you must adopt certain policies governed by the state that include specific information that are put forth by the statute. And there's a lot of information in that statute, so I definitely recommend that if that's something you're looking into, or if you want to explore, that you look up that statute for the Arizona opt-in option and see if that's something that would be better for your business. And overall, when it comes to drugs in the workplace, this is serious stuff, and I don't think that we have seen the last of these types of laws. Again, we are now at 14 states and counting, and it has been on the ballot for a lot of states almost every single election, even for the ones who it did not pass for this time. So this is definitely a growing and evolving topic in the realm of HR. So if you or your executives in the company are thinking of making any major changes to your policies in light of this new law, or you just really want to make sure that you are protected, we always highly recommend that you speak to an employment law attorney just to make sure that your company is not taking on any unnecessary additional liability. All right, so with that, let's go ahead and move into Colorado. So let's start with their minimum wage. Beginning in January 1st, or excuse me, on January 1st of 2021, the minimum wage in Denver, Colorado will increase to $14.77 per hour. In addition, there was a proposal in September regarding adjusting the state minimum wage for inflation per the Colorado state constitution. The Division of Labor Standards and Statistics made the announcement in September about this raise proposal, but so far we're not really seeing anything stating that if it was approved or passed or denied or tabled. And because we're so late in the year, I really don't think we're going to see anything for the beginning of January, but they may decide to pass something like this and make it effective in like March or April. So there's really no update on that yet, but that is a possibility that a statewide minimum wage increase could occur in Q1 of 2021. So keep that in mind. But as of right now, the raise is only effective officially in Denver. So as far as action items go, again, just make sure that you're conducting a wage audit to identify any employees that will not meet that minimum wage if you have employees employed in Denver, and just prepare to adjust their wages to meet that new pay that will go into effect on January 1st. Now, while we're on the topic of wages, let's go ahead and talk about the minimum salary threshold change for exempt, exempt employees in Colorado. Effective January 1st of 2021, the minimum salary threshold for exempt employees is going to be increasing to $40,500 from its previous $35,568. That was the old salary threshold. So keep in mind that this threshold will usually will increase annually until it reaches $55,000 estimated in 2024. That is the overall goal of these increases. So this is something that we will be revisiting each year. But as of now, the salary test is greater than the federal test. So this is going to take precedent in terms of the state salary test. As far as action items go, employers should conduct a classification audit and identify any exempt employees that are not currently meeting this threshold. And then you can actually decide to reclassify them to non-exempt, or you can increase their pay to meet the minimum before the effective date of January 1st of 2021. Next, let's go ahead and talk about Colorado's Equal Pay for Equal Work Act. So this goes into effect also on January 1st of 2021, and it does expand upon Colorado's current Equal Pay Act. The following are the expansion provisions to this act. So the new act actually prohibits wage discrimination based on sex or sex combined with another protected status. This was not protected in the previous act. And in addition, this new law now defines sex in terms of one's gender identity, which it did not do previously. Now, if there is a wage differential at any time under this act, the employer is not liable for discrimination if the employer can demonstrate that the differential is based on one of the following. So the burden of proof does fall on the employer, and you have to prove that any pay differential, I'm struggling with that word, is based on something like a seniority system, a merit system, a system that measures earnings by quantity or quality of production. For example, this could be a piece rate pay system in construction industries, a geographic location where the work is performed, education, training, or experience to the extent that they reasonably relate to the work being performed and the monetary amount assigned to the work, and then also travel, but only if it is a regular and necessary condition of the work. Now, even if the wage differential is based on one of these permissible factors, the employer must also demonstrate that they have applied the factor reasonably and that the factor accounts for the entirety of the wage rate differential. So these are important things to know that would fall onto you as a responsibility if you ever get audited. So as far as action items go, there are a couple of things that we advise that you do to ready yourself for compliance with this law in 2021. Definitely conduct a thorough and comprehensive pay audit of your workforce. Once you have completed that audit, be sure to identify and remedy any unlawful pay discrepancies as soon as possible. And you realistically should be repeating this process once every 2 years at the bare minimum, just to make sure that all of your compensation practices are compliant with any Equal Pay Act in any state that you do business in or have employees in. You're also going to want to comply with the new poster requirements for this law and update your employee handbook to reflect this new law as needed. As of right now, they haven't released any formal statements or formal updates, but usually around the end of December, 1st of January, once the poster is officially released as well, they usually have an attachment or an additional things to put in your handbook that can help you with the language on that as well. So another law we want to touch on briefly is the Ban the Box law that was passed. So this law officially went into effect on September 1st of 2019 for any employers that had 11 or more employees. So a lot of you may already be compliant with this law. However, in September of 2021, any employers with less than 11 employees will now need to comply. So for any of you that have employees in Colorado, you do business in Colorado, and you have less than 11 employees, this is something you're going to need to comply with, and you have about 9 months to comply with it, so not a bad timeline. But essentially, the Ban the Box law limits employers from asking applicants about criminal history on employment applications. So employers are no longer able to advertise or state in their job applications that a person with a criminal history may not apply for the position. It also disallows employers from asking about a person's criminal history on their application. However, employers can still obtain a person's publicly available criminal background report. Now, there are a couple exceptions to this law, and these are good to know. So the exceptions to the Ban the Box law is if another law bans people with criminal history from being employed in a particular job. So some example may be like security guards at banks. There could be a provision that says that if you're going to be a security guard at a bank, you can't have a criminal history. So there may be specific positions or specific industries affected by this exemption. Also, if an employer participates in a program that encourages employment of people with criminal histories, you are allowed to ask about that history. So for example, if you have an initiative where you have a commitment that 20% or 30% of your workforce, you want to be rehabilitating people who have a criminal past, then you can definitely ask about that in order to help with that initiative that you are encouraging that type of employment. So that is another exception to the law. And then finally, if there are any other laws that require a criminal history record to be checked for the position, usually this applies to federal or security type jobs, that would be another exception where you are allowed to ask about the criminal history. And violations of this law will result in warnings, compliance orders, or even civil penalties issued by the Department of Labor. So be sure to adjust your job postings and train your HR representatives or your recruiters who are posting these job applications to avoid being out of compliance. All right, and finally, the last law for Colorado is the Healthy Families and Workplaces Act. So this law is actually split with its effective dates, as you can see. So for employers with 16 or more employees, this law is going to go into effect on January 1st of 2021. So definitely it's coming up. Then on January 1st of 2022, all Colorado employers will need to comply with this act. So essentially, if you have 15 employees or less, you get an extra year to work towards complying to this law. But for any of you who have employees, a number of employees of 16 or more, you will need to comply as of January 1st. So this new law offers sick workers with up to 48 hours or 6 days of paid sick leave per year. Now, this sick time is accrued at 1 hour of paid sick leave for every 30 hours worked. It is available to both full-time and part-time employees, and it is capped at 48 hours per year. This law prohibits any retaliation and has detailed provisions related to providing notice to employees about their rights surrounding this leave. So the notice requirements are included in that in terms of communicating this with your employees. So in addition to offering the paid sick leave, this law also expands the FFCRA mandated sick leave to employers over 500 employees as well. So they were previously exempt from FFCRA, but now they will be required to offer it. And as of right now, we don't really know what's happening with FFCRA. There has not been an announcement that that is expanding or extending at all. It is still slated to end on December 31st, but that is subject to change. As far as action items go, there are a couple things that you need to do. Employers should definitely update your employee handbooks to include the new language for the paid sick leave. You'll need to contact your payroll provider to set up the accruals for this leave if you are covered, and update your postings for this law in 2021 as well. E-posters are available through Pay Entry now if you are working from home and you would like to go digital next year with all of your e-posters in order to remain compliant. You can either reach out to myself or Kathy directly, and we can definitely get you started on some pricing options for the e-posters. All right, next we're going to briefly talk about New Mexico. Not really much legal activity happening there in 2021, but the only major change is their annual minimum wage increase. So beginning on January 1st of 2021, the minimum wage in New Mexico will increase to $10.50 per hour. And for tipped employees, it will go up to $2.55 per hour. Now, keep in mind that some counties do have higher minimum wages than the state minimum wage. For example, both Las Cruces and Santa Fe counties have all been higher than the state minimum wage in the past. So definitely check your county minimum wage as well, because if it is higher than the state minimum wage, you will have to comply with your county minimum wage. So as far as action items go for this one, remember that the minimum wage increase for this particular state will be occurring annually going forward until the last increase in January 2023. So they have an initiative where their goal is to reach $12 an hour of minimum wage by 2023. So that will be happening every year until that date. Then as far as action items go, be sure to conduct a wage audit to identify any employees that will not meet the minimum wage in 2021 and prepare to adjust their wages so you are compliant. All right, next we're going to talk about our final state today, which is Washington. So first we're going to take a look at their minimum wage increases. Lots of minimum wage increases across the U.S. this upcoming year. So beginning on January 1st of 2021, the minimum wage in Washington is increasing to $13.69 an hour. The wage increase is the result of an inflation adjustment and not a voter-approved ballot measure. So this is a pure inflation adjustment for the state of Washington. So as far as action items go, again, just make sure you're conducting those wage audits and adjusting anybody's pay that needs to be adjusted so that way you are compliant effective January 1st of 2021. Washington has also made some adjustments to their minimum salary thresholds for exempt employees. So just to give you a little background on the exempt salary threshold in Washington, they will be increasing their salary threshold incrementally until 2028. So small companies with 1 to 50 employees will have a more gradual phased increase than larger employers. But essentially by 2028, the minimum salary threshold is expected to be at $83,356 per year. So that's going to be slowly increasing over the next 7 years. Now, effective January 1st of 2021, employers must begin to follow the new state salary rule schedule because it is now more favorable than the federal exempt threshold. So I do have a copy of the schedule on the next slide, which we will take a look at. But this is essentially the schedule it will be following over the next 7 years. So note on this table that there is a differentiation between small and large employers. So up at the top, you can see small employers between 1 and 50 employees. You are on a different schedule than the 2 columns to the right, which is employers with 51 or more employees. So this differentiation is also designated along the left-hand side in terms of the dates on which these increases will occur. Now, this particular table is subject to change on a yearly basis. So if they decide that they want to lower that goal threshold in 2028 or change it at all, they could redo this whole table. So I would not recommend saving this table and using it for every year until 2028. This is probably something that we will revisit every year at the end of the year to give you guys an update and make sure that the schedules have not been adjusted. In addition to these threshold changes, the state of Washington is also changing the job duties test to classify exempt employees. So these new tests are actually focusing on what work the employee performs rather than their job title or a generic job description of what they supposedly perform. So it's also important to note with these changes that Washington's new tests are not going to recognize exemptions for highly compensated executives. So what should you do as far as next steps? Well, firstly, you should definitely review your employee classifications and minimum salaries to identify any classifications that may not meet the new guidelines. If you do wish to maintain an employee's exempt status, you will need to ensure that the worker meets the new duties test requirement and is paid at least the minimum salary threshold requirements, even as they increase over the next 8 years. All right, and then the final law for Washington is the update to their sexual harassment requirements. So effective January 1st of 2021, new industries have now been added to the sexual harassment requirements as a means to protect employees who work in more isolated workplaces. So these industries now include hotels and motels, retail corporations, security guard entities, and property services contractors. In this new law, effective January 1st of 2021, employers within these industries must now provide sexual harassment policies in their handbook. They must deliver sexual harassment training to all of their employees, and Payentry actually offers sexual harassment training, so if you are interested in booking that through us, please let me know. Employers must also provide a list of resources regarding sexual harassment and assault, and employers must also provide a panic button or a means of summoning assistance from another coworker or employer representative during their shift. So as far as action items go, if you are covered under this law, you should definitely train your supervisory staff and HR department.
Brianna, I can't hear you. Hi, this is Kathy. If you can hear me, could you type into the question box that you can or can't? I'm going to unmute myself. And if Brianna, if you can hear me, no one else can hear you right now.
Oh, can you
So
guys hear
your
me?
slide is on.
Out?
Oh, we can hear you now. Yeah,
Oh, okay.
You've been gone for a while.
I'm sorry. What was the last slide? If you want, I
That's
can
okay.
go back.
It was the one before the question slide. I think you were the first of that, and it cut out.
Okay, do you want me to review this slide real quick then, and we'll just go over these one
Would
more
you?
time?
Yeah.
Yeah,
I
sure
heard
thing.
train your supervisory staff, and I think we lost you then.
Okay, so I was right at the beginning of the slide. Okay, so as far as
Mm-hmm.
the sexual harassments in Washington, definitely some action items for y'all there. Train your supervisory staff and your HR department on the law's requirements in terms of making sure that they understand who is required to have sexual harassment and make sure that you're compliant with that. definitely implement and update your policies. So if you don't have a sexual harassment policy, you will need to create one and roll it out in your handbook as of the first of the year. And then also provide sexual harassment training to all of your employees by January 1st of 2021, and that is coming up. So if you do need assistance with booking sexual harassment training, Pay Entry does offer it, so we can work with you on that as well. And then finally, you will need to compile the list of resources required to provide to your employees, and usually that's local contact information via the state as well as EEOC contact information. All right, so I apologize for the technical glitch, everybody. But this webinar is was being recorded. I will go back and look at the recording, and if I cut out at all, I'll just go ahead and re-record it. But those will be available on payentry.com under our webinars recordings tab, and you should be able to view the recorded webinar within 24 hours of today's live presentation. And then you'll also be emailed a copy of the live presentation as well tomorrow afternoon. All right, Kathy, do we have questions? I know that kind of blew up with not being able to hear me, but do we have any other questions?
There is one question. Is harassment training available for the entire company?
In terms of available, so we do sexual harassment training, and it is available for both non-supervisor and supervisors, and
Yes,
you can do it for the entire company. So yeah, absolutely.
For the Colorado Healthy Families and Workplaces, they're charged for the employee or employer.
No, so this policy is not like a paid family leave. It's not going to come out with a payroll deduction or anything like that. This is a paid sick leave, and the paid time off for the employees is going to be paid out by the company. It's not something that's funded through payroll deductions.
Okay. The other is number of employees in the state. This is about Washington. Is it based on the number of employees in the state, or is it the total number of employees overall for the company? They only have one employee in Washington at this time.
So if you are an employer in any of the states and you have at least one employee, the laws that are going to apply are based off of your overall company headcount. The only law that does not apply that way is FMLA, because you do have the 75-mile requirement. But if you have one employee in Washington, but you have 50 employees in your company, all of the laws that apply to 50 or more employers in that state will apply to that one employee. But you only have to offer it to your Washington employee. You don't have to offer it to the rest of your employees. Just that one that's residing in that state.
Like the salary threshold. Would you explain what salary threshold means? What it refers to?
Yeah, absolutely. So the salary threshold, if you have a non-exempt and exempt employee, non-exempt means they get paid hourly, exempt means they get paid on a salaried basis. And so a minimum salary threshold is the requirement either by the federal government or the state that says if you're going to pay someone on a salary, they have to be paid at least X amount of dollars annually for them to be considered a salary employee. So the federal government has a basic guideline for those salary guidelines, but just like their minimum wage, that salary threshold tends to be a little low, and states will go a little bit higher than that threshold. So essentially, Washington is changing that threshold to make the minimum salary higher.
Okay, thank you. At the beginning of the presentation, it was noted that they couldn't not download the PDF. So we may need to send everyone a PDF. I could not download it myself, so I'm not sure, but I was getting an error message. So we will send that out.
Okay, yeah,
to
definitely.
everyone. Okay.
I will add it to the email that goes out with the copy of the recording. It will go out tomorrow afternoon, so everyone should have a copy of that by tomorrow afternoon.
Okay, any other questions, anyone? Okay.
All right, well, thank you guys so much for your time. We really appreciate it. Again, if you are a multi-state employer, next week we're going to be talking about Georgia, Florida, South Dakota, Oregon, and Virginia. So if you have any employees in any of those states and you need updates on those laws, feel free to register for that webinar and join us next week. But we look forward to seeing you all there. If not, you guys have a great rest of your week.